Today, we'll be seeing the case of D. Saibaba versus Bar Council of India and see how the Supreme Court of India saved a handicapped man and his livelihood. D. Saibaba. The appellant is a handicapped person who also happens to be an enrolled advocate. Way before being an enrolled advocate, he used to run a STD telephone booth which was allotted to him under the handicapped person's quota. On the other hand, D. Anuradha, who is the wife of the appellant, is the respondent number 1 in the appeal. They got married on 4th December 1997. D. Sai Baba stopped sitting on the STD booth. Instead, he used to devote his 10 a.m. to 5 p.m. to his apprenticeship under a senior advocate. The operations of the booth were taken over by the retired father of the appellant. The wife filed her first complaint on 25th August 1999 under the Section 35 of the Advocates Act 1961 over professional misconduct, wherein the wife claimed that the appellant is running a STD booth while he was also an enrolled advocate, which is prohibited by the said section. The State Bar Council dropped the complaint on 6 November 1999. On the first complaint being dismissed by the State Bar Council, the wife files another complaint in front of the Bar Council of India. The complaint was identical to the one that was filed previously. The appellant responded to it by saying that the respondent has malicious intent. She even filed a criminal complaint against the appellant, who also happens to be her husband. The booth was allotted to the appellant way before he was enrolled as an advocate. And after the enrollment, D. Saibaba personally stopped operating the booth and it was operated by his parents, particularly by his retired father. The Bar Council of India on 20th Feb 2001 directed the appellant to surrender the STD booth so that there remains no doubt on the intentions of the appellant. The appellant asked for time to surrender the STD booth so that he could collect the outstanding dues from the daters, which would become very tough if he shuts down immediately. A little more than a month later, on 31st March 2001, the Bar Council of India ordered the deletion of the name of D. Saibaba from the roles of advocate. That means he was suspended permanently from his advocacy. After surrendering the booth license, the appellant requested to review the order on 26 April 2001. The appellant requested the Bar Council of India to recall and modify the earlier order of deletion of name. In the pursuit of interpreting the clause of review in the Advocates Act 1961, within 60 days of the order, which means that the limitation of the review is 60 days from the order and not from the communication of order. Hence, a clarity was required to interpret the law, which was later done by the Supreme Court of India, on the demand of both the parties, the Bar Council and D. Saibaba himself. The court observed that marriage was broken. Saibaba was only under apprenticeship when the whole controversy started. The court also said that it was an attempt to create a mountain out of a molehill and nothing else. Letting Booth remain in his name after stopping the operations was innocuous. Law of equity were followed and the previous order of Bar Council was modified. Now that we are done with the facts, let's go through the provisions mentioned in the case. Section 35 of the Advocates Act 1961. State Bar Council can send a case to the disciplinary committee if they have a reason to believe that the advocate has done something wrong. State Bar Council can move the case from one disciplinary committee to the other by its own, on the words of someone who is considered to be an interested party in the case. The disciplinary committee sets a date for hearing and informs both the advocate concerned and the Advocate General of the state. After hearing both the sides, the committee can either dismiss the complaint and close the case, give a warning to the advocate, suspend the advocate from practice for a set period, or remove the advocates from the state role, that is, permanent removal of the advocate. A suspended advocate cannot practice before any court in India or before any authority when he is suspended. If given notice, the Advocate General can attend himself or send any other lawyer on his behalf. Let us see Section 37 of the Advocates Act. If anyone has issues with the order of State Bar Council, then that person can appeal to the Bar Council of India. There is a limitation of 60 days from the date of order is communicated. The disciplinary committee of the Bar Council of India will hear the appeal. It can pass any order it thinks fit, including changing the punishment given by the Bar Council of India. Fair chance of being heard should be given to the appellant unconditionally. Section 38. Anyone affected by the Bar Council of India's disciplinary committee order, or the Attorney General of India, or the concerned state's Advocate General can appeal within 60 days of the order being communicated to the Supreme Court of India. The court can pass any order it thinks fit, including changing the punishment given by the Bar Council of India. Fair chance of being heard should be given to the appellant again. Section 44. The bar can allow review within 60 days of order being passed. The State Bar Council's review must be approved by the Bar Council of India. And the last provision mentioned in this case was Section 48AA. The Bar Council of India or any of its committee except the disciplinary committee can review its own order on its own or otherwise. The review must be done within 60 days of the order being passed. Now coming to my opinion, yes, the framework of the Advocates Act can seem to be very rigid, but it is made that way only to make sure that the advocates lead their career in the most ethical manner. And we also saw how the judiciary follows the equitable nature of justice, when the judiciary not only focus on the provisions but also focus on the facts of the cases. So thank you guys, do follow me if you love to see legally optimistic videos.